On June 7, 2026, the transposition deadline for the European Union's Pay Transparency Directive officially passed. The legal protections that allowed for opaque, proprietary compensation models have been removed. The directive introduced a specific legal mechanic known as the Presumption Juris. Under these rules, the burden of proof is no longer on the employee to demonstrate they are underpaid. Instead, the law assumes discrimination exists unless the employer can prove otherwise. This shift is triggered by simple administrative failures. If a worker requests their pay information and a company misses the 2-month response window, or if the enterprise fails to report its gender pay metrics to the regulator, the company is legally presumed to be discriminating. Once that presumption is triggered, the financial penalties are uncapped. This includes toll back pay for the duration of the discrepancy, compensation for missed promotions, and non-material damages for psychological distress, all accruing uncapped interest. Many executives currently view this directive as a routine HR administrative update. However, as the following statistical requirements show, treating this as a simple checklist creates a massive liability for any multinational with a European presence. While the 1957 Treaty of Rome enshrined the principle of equal pay, it remained largely unenforceable for decades. Corporations maintained a systemic opacity that made it impossible for external regulators to see the underlying data. Proving a case of discrimination required an employee to gather evidence they didn't have access to. They had to navigate a system where salary discussions were often prohibited, and compensation bands were locked behind internal portals. This dynamic began to change with the 1989 Danfoss case. A Danish labor union challenged a pay system based on a complex, opaque web of piece rates and subjective management evaluations that resulted in women earning significantly less than men. The Court of Justice of the European Union ruled that when a pay system is totally lacking in transparency, the burden of proof shifts to the employer. The company must prove their system is not discriminatory, even if the worker cannot establish a perfect case. Directive 2020/970 takes that 1989 judicial precedent and turns it into a strict liability shield. In this environment, a glitch in a reporting software is no longer a technical error, it is legal proof of systemic discrimination. Article 10 of the directive establishes the ultimate enforcement mechanism, the Joint Pay Assessment. This is a mandatory regulatory audit that multinationals must now architect their data systems to avoid. The assessment is triggered when a company reports an average pay difference of at least 5% in any single category of comparable workers. Article 9 requires companies to calculate this gap using both the mean and the median. The mean tracks the simple average, which is easily skewed by high-earning outliers, while the median identifies the experience of the middle-of-the-pack worker. The liability threshold is reached if either the adjusted mean or the median hits the 5% mark. This prevents corporations from using specific statistical averages to obscure an existing gap. If that 5% threshold is hit, the enterprise enters a 6-month remediation window. Companies with 250 or more employees must file their first formal reports by June 2027, using data they are generating right now. For a company running a pre-compliance audit today, a 5.1% gap means the remediation clock is already running. Identifying this gap forces an immediate choice. The enterprise must either retroactively adjust its payroll to fall below 4.9% or produce a bulletproof mathematical proof that the difference is legally justified. When a category hits that 5% threshold, companies often attempt to justify the gap using subjective manager notes about performance or tenure. Under the new directive, regulators will no longer accept these qualitative excuses. To legally justify a pay gap, the employer must use a specific statistical tool, the Oaxaca-Blinder Decomposition. We can visualize this model like an audio mixing board, where the master output is the total pay gap. The model mathematically strips away observable background tracks, factors like tenure, education level, and geographic location, to isolate the single variable of gender. The portion of the gap that can be undeniably attributed to these objective factors is the explained variance. This is the only portion of the gap the company can legally defend. Any remaining gap is the unexplained variance. In a court of law, this remainder is treated as potential discrimination. This regression model is only as good as the data feeding it. If a company's performance management system relies on subjective ratings that historically favor specific communication styles, the entire explained variance becomes legally compromised. If an auditor determines a performance metric is biased, they will throw that variable out of the regression. The explained portion of the gap collapses, and the unexplained gap spikes well beyond the 5% liability limit. The directive has made advanced statistical models mandatory, but those models become evidence of discrimination if the underlying performance software used by the enterprise is fundamentally biased. Article 3 expands the definition of pay far beyond a base salary. Remuneration now includes every complementary and variable component, including bonuses, overtime, and occupational pensions. This creates a massive data normalization challenge. For example, a company must find a way to mathematically reconcile the value of a German company car with a flat cash travel allowance provided to a worker in Ireland. Normalizing these values requires local tax expertise to calculate personal use percentages and convert benefits in kind into a gross annualized cash equivalent that is consistent across the entire workforce. The data extraction must be incredibly granular. Employers have to distinguish between days not worked but paid by the company, such as vacation, and days paid at a reduced rate from state budget funds, like certain types of parental leave. Moving this highly sensitive, disaggregated tax and health data across borders to centralize it for an equity report creates an operational catch-22. It instantly triggers severe GDPR scrutiny. Enterprises are legally required to complete a data protection impact assessment before they can even run the software to check their pay equity. Attempting to gather the data required to defend against the Pay Transparency Directive can inadvertently lead to massive GDPR violations if the data pipeline is not architected perfectly. Under Articles 4 and 9, companies can no longer rely on legacy pay grades. If a 20-year-old grading framework was built on historical market realities that undervalued certain roles, using that framework is now a direct violation of the law. The directive mandates that roles be grouped using gender-neutral criteria. This requires a mathematical weighting of soft skills to ensure they hold equal value to physical or technical effort in an audit. Labor economists must now quantify the physical caloric output of a warehouse worker against the cognitive load and adrenal strain of a support agent de-escalating clients. These job valuation criteria cannot be decided unilaterally by the company. They require documented cooperation and co-determination with workers' representatives and labor unions. Job valuation is no longer an internal financial exercise for the CFO. It is a heavily regulated negotiation, where the methodology must be signed off by the union before the numbers are even run. If the math fails, the gap remains unjustified, and the 6-month remediation clock runs out, the enterprise enters the Article 10 Joint Pay Assessment. This is a comprehensive, invasive dissection of the business. Regulators demand detailed information on average pay levels, bonus structures, and every variable component across the entire organization. The assessment focuses heavily on mandated catch-up pay. If a job category received a market adjustment while a worker was on maternity leave, that worker must receive the full adjustment the moment they return to work. The power dynamic shifts entirely. Labor inspectorates and unions are legally mandated to participate in meetings determining how the company fixes pay gaps. Failing to meet the mathematical standards of the directive results in a company losing control of its own compensation strategy to external labor organizations and regulators. These mandates apply to any multinational operating within the EU, regardless of where its global headquarters is located. Massive tech companies in the US and manufacturers in Asia are currently building hyper-transparent compensation architectures for their European branches just to maintain legal compliance. This creates a situation where employees in New York or Tokyo will eventually see the exact visibility and legal guarantees provided to their colleagues in Europe. It is administratively and culturally unsustainable for a global company to run a black box philosophy in one region while operating a legally enforced glass house in another. By removing the legal protections of secrecy, the European Union has established a new baseline for how global companies must value labor. The era of management discretion is being replaced by a model of mathematical justification.